Good afternoon, everyone. My name is John Hurley. I'm your judge. This afternoon, we're in first appearance court. You're in, today is the day the court determines whether or not there's probable cause in some circumstances. It's proof evident presumption, great. However, remember, you have the constitutional right to remain silent. But if you give up that right, what you say today can and will be used against you. Also, if you have a private attorney, let us know who that is. We'll contact your attorney and let them know that you're in court this afternoon. Now, somebody, the family or somebody come on up. Ma'am, raise your right hand. Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Tell me your name, ma'am.
Megan McSweeney.
McSweeney. I remember you. I remember that you were the alleged victim. Because I only knew another McSweeney, and that was when I was in college. So I remember this. Now, your boyfriend was arrested for a domestic battery case, right? And apparently, that case was, we call upfiled from a misdemeanor to a felony. And apparently, this case was tell us the name of your boyfriend.
Dustin Murdoch.
Murdoch. Apparently, this case was handled by Judge Cohen yesterday, right? A male judge?
I believe so.
You were in court yesterday?
No, I had no knowledge of the court date yesterday.
That's fine. I've been told it was Judge Cohen. Am I correct?
That's, Your Honor, my information is bad. I've been informed that Judge Cohen is the one.
Was it Judge Cohen? Was it a male judge?
Will the other judge, Jails, cut the mic?
Thank you.
My understanding, though, is the order that's been issued, what was told to me was that it was ordered by Judge Cohen. And it's his case now. So I don't know the circumstances. For all I know, Judge Cohen's going to be dealing with it.
Does he have another court date? Do we know?
I'd have to check.
Let me
Yeah, there have been periods where hasn't been violence, but he keeps getting in trouble for violence.
Let me hear from the mom. Ma'am, come on up.
When he got arrested.
Raise your right hand.
Okay.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, put your hand down. Tell me your name, ma'am.
Yeah, Teresa Martin.
Nice to meet you. Nice to see you again, Miss Martin. Go ahead. You're the mom, right?
Yes.
Okay, go ahead, ma'am.
Okay. When he was arrested on this charge,
Okay.
he was in jail for almost 2 months. And then he got a public defender, and then they did a motion to reduce the bond, and because it was originally set for $50,000. Okay. And then about approximately 2 months later, maybe a little earlier, he did get the motion to bond. They brought the motion, the bond down. Okay, and
For what?
I think it was $2,500 for assault and
Like-
$2,500 for the battery.
Yeah, but
So
are you
we-
talking about on this case?
Yes,
Well,
yes.
yes, they were reduced to $2,500 each, but I can also tell you this, Judge, because that was before the charges were upfiled. I'm getting some printer paper because I would really like. I think
Did he
that
bond out on that 2,500?
Yes, and he had an ankle monitor put on it.
I got
well,
it.
Your Honor,
Okay.
I got it. So then, in the meantime, they raised the charge to a felony charge, and then he got taken into custody.
Right, yesterday we just went to court because he had a calendar
I
call.
understand.
Okay.
I'm gonna print out for Your Honor. One moment.
Who reduced the bond to 2,500? Was it a man judge or a female judge?
The female, Kathleen McHugh.
Kathleen McHugh. I went to high school with her.
Yeah,
A little bit younger than me.
and he did get his job back. You
Yeah.
know, he's been working
Oh, no.
for 10 years.
Wait.
So he's living with his dad, and
How long has he been he just was in custody yesterday, right? Who's the
Yes.
who's the bondsman you used?
you know, actually,
Your Honor.
Yeah.
I'm sorry. If I could print out Ms. McSweeney's statement, because that was only taken a week ago. It was taken October 23rd. Those bond reductions were done before. And I think there's some significant things in her statement that Judge McHugh was not privy to that I think the court should take into consideration.
Okay, let's put it this way. My gut feeling is to split the baby. Maybe not 50,000 now, but he's been on bond. Apparently, how long was he out on bond?
couple weeks,
Couple weeks.
he went back to work.
A whole 2 weeks.
Yeah.
Your Honor,
I may lower the bond and keep the ankle monitor on.
and frankly, I don't know if Judge McHugh would have reduced the bond if she'd known that the total allegation, when what Ms. McSweeney informed our office, is that when he
Allegedly
did
came
break
after-
into the room,
Right.
had a steak knife in his hand and threatened to kill her and rape her.
Interesting. Interesting. Assuming that's true, assuming you're not lying about what did or did not occur.
They do state, he was.
Okay, that even makes me more concerned. That he, I mean, to blame it on drugs is one thing, but the fact that if he behaves this way on drugs, and I can't stop him from doing drugs, that's what concerns me. Whether it's drugs or he's got a bad temper, going after a loved one with the steak knives, pretty darn serious.
I can tell you, and I'm looking at the statement from their friend, who has told the police that while this is the first time he's threatened to kill her with an actual knife, there have been many other cases of him abusing her, both verbally, mentally, and also she describes him as a violent person, Your Honor.
Okay. Okay, here's what I'm gonna do. I'm going to reinstate the original bond at $50,000. And if you wanna have relief from that, if the defendant wants to have relief, he's gotta go back to either Judge McHugh or Judge Cohen. And I previously determined his ability to pay bond. I previously, when he was first arrested, I determined, the bond conditions. I'm gonna rely on that prior colloquy regarding his ability to bond. But frankly, I'm not sure Judge McHugh would have lowered that bond that significantly if she knew that there was a steak knife and a threat to kill. I think that what happened was Judge McHugh set the bond, and her statement, Ms. McSweeney's statement, came after that. I have a feeling if Judge McHugh would have known that at the time the bond was requested to be reduced, She may not have reduced it. I can't speak for Judge McHugh, but I'm sure she would have definitely had a different consideration on things. So, yes, ma'am.
The state, when we're at court, not at this calendar call, but at the motion to set the bond,
Yes, ma'am.
he did say, the state did say, you know, what about, you know, a knife being involved, and that the case wasn't open, but they were going to open a new case. So she did know.
So you're saying that Judge McHugh did consider the knife?
He did know that.
I don't see how she could, because I can tell you, there was no evidence. While Ms. McSweeney might have told someone at our office this, there was no formal evidence to provide, because her sworn statement was taken October 23rd. So we could not provide that to Judge McHugh to read it for herself. At that point, it's just speculation, Your Honor. And like I said, if you'd like to, I'll print out. I need more. I'll give you the statement. You can read it for yourself.
Ma'am, I'm gonna leave it the way it is. All right, I'm gonna leave it the way it is. You seem like nice people. Both seem very nice, and we had to get you down here twice. I'm kind of doing this on the fly. I don't usually, we don't have a defendant. I didn't have paperwork. Look, here's the thing. He allegedly made threats to kill Miss McSweeney. Whether he was on drugs, whether he had a clear mind, the court is very concerned about her safety and perhaps the safety of your grandchild. He's got a serious criminal record. I set the bond originally at $50,000 on a misdemeanor. Since then, it's been raised to a felony. I'm not going to reconsider and raise it above the $50,000. I'm just going to leave it the way it is today. And I think that's very fair. Now, his next calendar call, or you can reset a bond hearing in front of Judge McHugh or Judge Cohen and let them review this again. Maybe Judge McHugh will reset it back at $2,500 to do something, but I really think that's where it needs to go. All right? Ms. McSweeney, thanks for coming to court. Ms. Martin, thanks for coming to court. I'm sorry we had to meet like this, all right?
I have
Yes,
one
ma'am. Go
question.
ahead, ma'am.
Because since they upgraded it, it looks like it went out of Ms. McHugh's handling it, and now it's Cohen.
Right. It may not be in Judge
There is a-
McHugh's courtroom anymore. It may be in Judge Cohen's courtroom. That may be, is a practical matter. It may not go back to her. It may go to Judge Cohen, all right? Thank you.
So there's no bond still, right? No bond?
I'm just gonna leave it the way it is. I'm not gonna disturb it. I'm gonna put it back at $50,000. Can I have an order for that?
Yes.
Count one's a
Blank order or something?
count one's the felony, count two's the misdemeanor, right?
What's that? Yeah. No, we got a bunch over
Okay,
there.
thank you very much. Thank you. Mr. Orlando, you want to step forward?
Yes, Judge.
May I see Gerard Nelson? Gerard Nelson. Oh, boy.
Ryan facility, Your Honor.
Got him. Mr. Nelson, you're being represented by Conflict of Regional Counsel in the courtroom. They're similar to the public defender. They're just in a different office. They're in the courtroom. Mr. Orlando, you're either the head of the office or?
I'm the managing attorney.
Okay. Thanks for coming to court. I didn't know we were going to bring over the higher ups here today, but I'm going to appoint you. The public defender has a conflict.
Judge, I have a form order. There is a finding that you're supposed to make that essentially says that you're granting the public defender's motion
Right.
to withdraw, which has been filed. But I haven't seen it, but I know that they.
Well, they did, and I realize there is a conflict, and he was previously found indigent, am I correct?
Assume so.
Okay, so, let me do this. Am I signing the right thing here?
Below that check, Judge, you had to make another mark in reference to the public defender's motion being granted.
Okay. Okay. I don't know. I think I just signed it at the end, I believe, right? Okay. Now, here's where we are. What's count 1 and 2 on this, gentlemen?
Your Honor, count 1 and 2 are, 1 count of human trafficking, and count 2 is a possession of cannabis.
Now, I found proof evident presumption great on the prior human trafficking.
Yes, you did, Judge.
I don't know, have you had an opportunity to speak with the prosecutor on this?
No, Judge, but I must be looking at something different. I'm looking at it, I was given an information from the public defender that shows,
On the information, those 2 counts are going to be count 1 and count 7.
So it's a
how
little,
many counts of human trafficking are there?
There's 3 total counts. When he was first arrested, he was arrested for 1 count of human trafficking, 1 count of possession of cannabis. Every other count on the information is an ad charge, and that's what he's here on today, all the ad charges.
right, so
Which
you're gonna,
consistent-
you're gonna have an amended information soon, right?
No, I've already provided it.
Okay.
It
And
is.
how many counts are on that information?
Well, on this, there are 7.
Okay,
There's 3 total counts of human trafficking. The one from the original count that you had heard the first
Right.
appearance on, 2 more counts. Then the 1 count of interfering with custody,
right,
use of the two-way device to facilitate a felony, 1 count of battery, and then the possession of cannabis that you also heard at his original first appearance.
right,
So that's why we're just here on the 5 ad charges.
right. I've got it right here, I'm sorry, I've got the information. So, here's what the court has already done, Mr. Orlando. On the prior human trafficking, when it came before the court found, based on the affidavit, based on the facts of the case, the court found there was a proof evident presumption grade standard met, and the state had sought to foreclose bond and release conditions, and I granted that. On count 3 and 4 today, those emanate from the same basic activity based on what I see from the affidavit. Now, if I find, are you seeking a foreclosed bond on those?
Yes, Your Honor, and I think in the PC affidavit I provided, I believe there's some additional information from the first one, and that involves information regarding the alleged victim, JM.
Right.
Because in the first, count 1 deals with the alleged victim, SW, and this also includes the allegations regarding the controlled phone call made by the undercover detective, and that would be the 3rd count
Okay.
of the trafficking.
Go ahead.
Our plan would be to set an Arthur hearing in front of Judge Usan,
Okay,
where we can have more of an evidentiary hearing to
understood.
address this. So we
Well-
would just hope that your rulings don't foreclose
No,
that
they don't.
option.
No, it's not. No, what I'm going to do is I'm going to find proof evident presumption grade on count 3 and 4 today, based on the court's prior statement of the court's prior ruling on count 1 and 2. The court will order count 5 interference with custody, 1,006 two-way device, 1,007 battery, 1,000 no contact with JM. That is Juliet Mike, no contact with that additional defendant. The court's going to find that additional victim. Court will find proof evident presumption great day, and your manner of relief today will be to seek a bond through an Arthur hearing in front of your trial judge.
And he is also scheduled for his arraignment before Judge Usan on Monday morning.
Okay, Mr. Orlando, is there anything else you need to speak of?
No, that's it, Judge.
Thank you. It's good seeing you again, sir.
Thank you. Good seeing you.
Okay.
Your Honor,
Yes, sir.
before we go on to the next case, I need to make sure, on Dustin Murdoch's case, there's 3 counts. Are you okay with 30,000 on 1, 10 on 2, and 10 on 3? Also, were you putting them back on pretrial?
Yes, the GPS.
Okay.
Okay. Now, sir, which case are you on today?
What is that?
Step right up here. Who are you here on?
Harland, Zerilla?
Zerilla?
Yeah. Yes, sir.
Okay. Who do you work for?
Truly Nolan.
Oh, what do you do there?
I do pest control.
You do?
Yes, sir.
All right. What's his second look? Okay.
Copy, Your Honor.
Okay. Name my letter real quick. Okay. Zerilla, you said?
I don't know why they put so many felonies on there.
Is that a misdemeanor or felony?
It's felony.
Felony, okay, just give me.
No. know that person? Where? Standing at
Okay,
the podium.
Harland, Zerilla at Conti. There's right there. Okay. Sir, will you raise your right hand for me? Do you swear or affirm to tell the truth, whole truth, and nothing but the truth?
I do.
Yes.
Okay, tell me your name.
My name?
Harland
Brian
Zerilla.
Zerilla.
No, I'm not talking to you, Mr. Zerilla. You could. What's your name, sir?
Brian Zerilla.
And how do you know Mr.
He's,
My brother.
he's my brother.
He's your brother? You can see him over there. Do you see
Yes,
him? There you
yes.
go. Okay. He's here for distributing, delivering cocaine. Is this a 30-day?
No.
Second look?
Yes.
Okay, let me just look here real quick. Matt, Judge Destry handled this originally. Put a
Yes.
$50,000, a $7,000 bond. Total bond was $57,000. I don't know if he had criminal record. I don't know.
Showing 2009 DUI, 2004 resisting without violence, 99 Bat Leo resisting with violence, unauthorized use of a driver's license, and depriving an officer of a weapons or communications device.
Got it.
For bonding.
Okay, let me see. Controlled narcotics purchase. During the narcotics transaction, the confidential informant met with the defendant handed $650 to the defendant. The defendant then handed the defendant 16 grams of field-tested cocaine. So, he's allegedly dealing in cocaine. Now, he's your brother. Does he
Yes.
live with you?
No, he lives with my parents.
How long has your brother lived here in South Florida?
A long time.
Does he have children?
He has none.
Does he own any land or property?
My parents do. That's about it.
Your parents own a
Yeah,
home or
they
something?
They own the home in Sunrise, yes.
Okay, and has anybody tried or attempted to bond this gentleman out of jail, your brother?
Before it was raised, I was going to, but he got
What was
arrested
it
at
raised from?
6,000, I think it was.
Total of 6?
6,000 to 57. I can't afford that.
Okay.
And
Hey, do you have any comment about bond on this, John?
I mean, I wasn't here for the his first appearance, so I really don't know what the court's reasoning was.
Were you gonna you were going to
well, I just took a second job to try to get
yeah,
something.
what other job are you doing now?
I'm working at a restaurant.
Really?
Yes, trying to do serving to see what I can gather up. I'm talking to lawyers.
Is this trafficking? No, it's
No.
distributing. Okay.
I read the PC, so I have knowledge about it now. But
Read the how did you know it was a PC?
I went to college. I wanted to do criminal justice, but
Where'd you go to college?
I went to McHenry Community College.
Oh, really?
But because I got a full ride for soccer.
Did you?
Yes.
That's great. Okay. I'm gonna lower this bond to $3,500 today on count 1,
Thank you.
and then what's count 2 again? Count 2 is what?
Um,
I'm gonna release him ROR on count 2. All right?
Your Honor, can I? Oh, no, that's perfect. I actually want, but I would like to talk to him too about
Well,
So, yeah.
how long has he been in jail now?
a week. I really do want to get him help because I see that's more what he needs. Like I want
What does he need?
to,
Hable eso.
I want to.
Does he have a drug
Hablando.
problem?
No, not that. I just want to get him help, get him situated with everything. He's a barber. That's what he does. That's his profession. So I
Okay.
want to.
Well, look,
I want
you
to
can
be.
bond him out.
I kind of want to. Yeah.
His bond on count 1's $3,500. Count 2 is gonna be ROR.
Okay.
You can bond him out of jail. I hope sitting in jail a week he learned his
No, he
maybe
definitely.
a little bit of a lesson.
I
all right?
appreciate it. Thank you
Do
so
we
much.
have something here? His name is Zerilla. Okay. All right. So let me see here. Okay. So you can go post his bond, all right? And I wish you the best of luck.
Thank you so much. I
Hey, let me,
appreciate it.
let me ask you a question. All right, you're done, sir. Thank you. Missy Joshua Leven. I'm going to skip ahead here.
With the court's permission, can I ask the court to please call Alica Robinson? The deputies have asked me to bring her up first. She's got some issues. She's on page 3 of the docket, Your
I
Honor.
understand. Ms. Robinson?
Ms. Robinson is approaching. Your Honor, I believe Ms. Robinson has previously been found to be incompetent, and she may still be incompetent at this point.
Okay.
In which case I don't...
Okay. Her bond is $500 on count 1.
Right.
I'm going to order this be transferred to Central and sent to Lerner Rent, all right?
Yes, Your Honor, although I think there's an issue with holding someone who's been found to be incompetent in custody on a misdemeanor. I'm not sure what the case law is on that, but I believe there is an issue.
The case on that case is with holding someone indefinitely. Your Honor is setting a bond. First of all, you're not holding her. You're setting. She has a bond. Secondly, you're transferring her case where she will be heard by Judge Lerner Rent to deal with.
I'm going to get her over to Judge Lerner Rent, all right?
I'm not complaining, Mr. Linder. I'm just trying to bring it to the court's attention.
I understand. I'm going to send her to mental health court. I released her our warrant. Count 2, count 1 is a warrant. $500 not showing up in court. So this goes to Lerner Rent. Thank you.
Thank you, Your Honor.
Yes, sir. Now, Joshua Leven, come up, please.
Go this way.
All right, so then Monday.
Mr. Leven, you're charged with burglary of a conveyance and grand theft. The court finds probable cause. I understand that Mr. Leven got arrested with an ankle monitor on, and I wanted to find out.
Trying to find his.
What was he on pretrial for?
Possession.
Have your face.
The guards beat the shit out of him.
Are you working at this time, Mr. Leven?
Yes.
Okay, and what type of work is that?
I have an online business and I also personal train people.
Do you have any money in the bank?
A little bit.
Okay, how long have you lived in South Florida, sir?
My whole life.
Okay. Do you have priors or?
In addition to this pending case, 2011 burglary of a conveyance, 2012 possession of marijuana, 2009 grand theft. End of record.
Got it. All right, Mr. Leven, it's alleged you went into a woman's car, stole her purse, $400 in cash, sunglasses, passport, credit cards, valued about $592. That was in the parking lot of D'Angela's restaurant in Weston. She allegedly confronted you. And then at that point, I believe you dumped her property, jumped into a tow truck. You didn't know the tow truck driver, and allegedly tried to fight the tow truck driver. She positively identified you as a perpetrator, and when they found you, you were allegedly wearing a GPS ankle monitor because you're out on a drug charge right now. So that drug charge, your judge signed a warrant, so you're going to be held on that. And I do note this is not the first time you've allegedly burglarized a vehicle, so I'm going to set your bond on count 1 at $7,500. Count 2, the grand theft, I'm going to set that at $2,500. Your new bond's there at $10,000, and you can bond out, but you're not really going anywhere because you're being held on that other case. Thank you, sir.
For the record, Your Honor, Mr. Leven has declined the services of the public defender. You can step away.
Missy Efrain Nevado.
PC argument, Your Honor.
Mr. Nevado, sir, you're charged with domestic battery. The court finds probable cause.
Your Honor, I have an argument.
Oh,
Can I make that?
I'm sorry, sir. Sorry about that.
I know. I don't have them that often, so.
Go ahead. No, I just get ahead of myself here. Go ahead.
Second page, Your Honor, first paragraph. The alleged victim advises she's not sure which hand he used to touch her, to grab her in the front of her neck, and the officer advised that there were no visible marks on the victim's neck. After conversations with my client, I would argue, Your Honor, that there is no probable cause to believe this woman was battered by him. I believe that this is all a fabrication, and I would ask the court to release him on his own recognizance. Beyond that, Your Honor, Mr. Nevado has been living in South Florida for 14 years. He is 4 years at the same address. He has 3 children he supports financially. He works, he owns his own car wash business, does have a place to stay, separate apartment with this alleged victim, no money in the bank, and no property.
Okay.
So she's lying, but she won't lie about which hand he used, and she won't lie that it's a more serious offense rather than a less serious.
Go ahead. Let me ask, ma'am, did you have contact with the alleged victim? Ma'am?
No, sir.
Not in fear?
Checking his prior record.
No, I already
right
did.
now.
You already told me. He had a harassment, contempt out of Florida at one point, and allegedly, sir, I'm going to set your bond at $1,000. I'm going to order for the time being. You have no contact, directly or indirectly, with Denise Nevado. Do not call her. Do not text her. Do not email her. Stay 500 feet from her at all times. It's where she lives, works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, or ammunition while you're on bond. Thank you. May I see Jeffrey Cravens?
Craven's present at the main, Your Honor.
Okay, hold on. Okay. Sir, you're charged with a battery, domestic violence, resisting arrest. Court finds probable cause. State, do you have any priors on this gentleman?
Out on bond for possession of methamphetamine drug paraphernalia.
Okay, what's the case number?
14-1255 CF10A.
Okay, sir. Anything else, Mr. Miller?
Almost seems pointless, Your Honor.
Okay. Allegedly, you put your hands on a woman's chest, neck, pushed her to the ground. She had redness on her cheek and around her chest and her neck. The argument allegedly was that you had taken her bong and possibly broke several other bongs in her storage unit. And that appears to be what the conflict was about, allegedly. And they found you hiding under a vehicle. So, sir, I'm going to assume you have no money, excellent ties to the community, but I'm going to set your bond today at $3,500 on count 1. Count 2 will be $1,000. Your total new bonds will be $4,500. I'm going to order that you have no contact, directly or indirectly, with Jennifer Hampton. Do not call her, do not text her, do not email her. Stay 500 feet from her. That is where she lives, where she works, goes to school, anywhere in between. You're not allowed to possess guns, firearms, ammunition, any other weapon while you're on release. Now, I'm going to revoke your bond on 14-1255 CF10. You're out on a methamphetamine case. Thank you.
Thank you, Your Honor.
Neely? Jimmy Neely.
Not the main.
They may not have brought him back from court yet. He was arraigned this morning. Your Honor,
He's at the Ryan facility, Your Honor.
Got it.
don't know that I'm getting invited to a meeting, but I'm not really being invited. I'm more being ordered.
Yeah.
But at least yeah, exactly. Did you get that? Your Honor, just so you know in advance,
Go ahead.
bond was originally set at $500,000. He's out on probation. Just in the rationale, Your Honor, he was out on probation for aggravated battery with a deadly weapon against the same alleged victim. I guess she's not alleged in that case.
Okay.
I use that word too much.
There you go.
So,
Now. Okay. So this is an ad charge, or is this a?
No, it's change charge.
Okay. Hold on one moment. I'll be right back. I have to take a quick break. I'm expecting something. Can I help you?
Just observing.
Oh, okay. It's now. Which case you?
McKinnon, page 2 of the felony docket.
That's, Your Honor, that's the case you reset from yesterday with
I'm
Mr.
gonna call up
Rotterman.
McKinnon real quick. McKinnon.
Mr. Rotterman's case, the 30-day from last yesterday.
Was he supposed to be here?
I think
Right, it was deleted. I just wanted to make sure it was deleted. Judge Shear had the hearing this morning on the VOPs. She denied setting any bond on the no bond. And we spoke about this case, and they moved to withdraw their motion for a warrant. So it's gain time while he's there.
Okay, thank you.
Thank you.
Take care. All right, what's your name, sir?
McKinnon, sir.
Okay, hold on.
is that him?
Your last name is McKinnon?
Yes, sir.
Oh, that's it? Okay, your attorney already took care of it. It's already taken care of. It's off the docket, all right?
Okay.
Thank you, sir.
Let's try it again.
Okay. All right, may I see Jimmy Neely, please?
know about it.
No, apparently not.
Oh, we did facility, Your Honor.
Like I said,
Mr. Neely?
where do I go?
So you're here for aggravated battery. That's a warrant, I believe, right? Or it's an ad charge? What is it?
Noon?
State?
12:30? Yeah. Your Honor, this was the case where originally you had set the bond at $500,000. He's already out on probation for aggravated battery against
So
the
I'm
same
merely going to
victim.
reinstate your bond of $500,000 with all the previous conditions attached to it. Thank you. May I see Venia Alexis, Stephanie Pantuliano, Gina Paluccio, and Kevin Bain.
Venia Alexis is at the main jail, Your Honor.
Okay, no driver's license, ma'am. Miss Alexis, I have a document that says you don't have a driver's license. All right, State, do you have anything on Miss Alexis?
No Broward priors.
Ma'am, you're from Fort Lauderdale, right?
Yes, sir.
Ma'am,
Yes, sir.
ma'am, apparently you're driving with no driver's license. Like, you don't even have an ID card? You don't have any?
I do.
Do you have an ID card?
Yes, I do.
I'm going to release you on your own recognizance and just chalk this up to bad judgment. But, ma'am, you have no license. You're not allowed to drive a car, all right?
All right.
Thank you, ma'am.
Okay, thank you.
You're welcome. Thank you.
Yes, ma'am.
Excuse me, Your Honor.
Go ahead.
Conti will need a Spanish interpreter.
Yes, sir. Okay, you want to call Spanish? Stephanie why don't you wait about
Except for
Pantuliano.
That's you?
No, he just said my name a minute ago.
Where's Stephanie?
except for tomorrow.
She bonded out, Your
She
Honor.
bonded, okay. What about Gino Paluccio?
North per hour. North per hour.
Got it, ma'am. You're charged with grand theft auto, Miss Paluccio. Ma'am, somebody posted your bond. You'll be out of jail shortly, ma'am. Thank you. How about Kevin Bain?
North per hour. North per hour.
Kevin Bain, loitering or prowling, sir.
I don't have that, so the officer telling me I have to wrap that. But I am gonna be writing this place, or writing, and, Jesus, come on.
Okay. I mean to tell you. All right, Kevin Bain, loitering and prowling, sir. Mr. Bain,
What are you talking about? He set the bond at $50,000 on this guy.
But you got how many charges you see?
We filed 3 counts. I'm telling you, we filed 3 counts.
all right, I'm going to do this.
Give me the case number. Here's
Mr. Bain, I'm going to release you on your own. Let me ask you, hold on. State, is he a sex offender?
Who is this
Anything
judge?
like that? Bain, B-A-I-N.
One moment.
B-A-I-N. Mr. Bain, are you working at this time?
He's on today's.
No, sir.
You have money in the bank?
Should be on today's.
No, sir.
Where'd you go to high school?
Sheila.
South Broward High School.
Sheila.
Go ahead,
Is there a problem with the way I did it? What, and what's, is he registered? And, excuse me?
Kevin Bain?
Yes.
Looks like he's got a pending ag bat.
Got a pending aggravated battery?
From June, it looks like.
From when?
June.
This year.
From June?
Looks like he's a designated career offender.
So I'm going to set your bond today at $50. You can bond out. Thank you.
That's all right.
How about, may I see Eric McDonald, Samer
How you doing,
Zuniga,
sir?
Brandon Precciocchione, and Michael Weller. Eric McDonald.
How you doing, sir?
Good, sir.
Your Honor,
Disorderly
probable cause
conduct,
argument.
breach of the peace, resisting arrest.
Probable cause.
Okay, screaming and yelling caused people who live in the apartment complex to turn their lights on and open their door to ask what was happening. Several warnings to lower his voice. He continued to scream. I'm yelling, "I'm going to kill you." And this allegedly occurred in the evening, late in the evening. So, what's your probable cause issue, sir?
I don't see here where the police are identifying that they were executing a lawful, in the lawful execution of a duty. The police don't put on here for for the resisting or obstructing without violence that they were actually
I'm not going to give him a
illegal
bond.
duty.
I'm not going to give him a bond on that.
So that's the one where there's a $100
I think the heart of the issue is the disorderly conduct. Go ahead, state of their priors. I'll release him ROR on count 2.
Thank you, Your Honor. Mr. McDonald's 26-year resident of South Florida. He's lived with his mother for 26 years. He works at the labor pool supporting 2 children. He has no money in the bank, no property.
Go ahead. You've got
He
anything?
does have very strong family ties.
Got it.
Possession of marijuana in 2009, 2007, resisting without violence and trespass.
So I'm going to release you on your own recognizance. Try to stay calm at all times, all right?
Thank you, Your Honor.
Thank you, sir.
What about...
Good luck.
All right, yeah, man, I'm passing that through.
Samer,
She was out on
Zuniga.
something.
She was out on something?
Who are you? Weller.
I'm passing.
On Palucci, she's out.
Zuniga. Samer Zuniga.
Bonded.
How about Brandon Petrocione?
Bonded.
Bonded. Michael Weller,
President the Maine.
violation of probation. Sir, on a DUI. Just give me a quick moment, Mr. Weller.
Sir.
Could you do me a favor? I gotta get this freaking email out.
Okay,
to
sir, you gotta,
this email out to Tara.
you're gonna have to go see your judge. Your bond's $500. Bond out.
Good luck.
Okay, now see Edward Frey, George Osceola, Rodney Lubin, and Kevin Smith.
Paperwork.
Frey.
Is it?
Frey is President the Maine, Your Honor.
No, that's not Frey.
That's not Frey, that's Osceola. Where's Mr. Frey? Your Honor, Mr. Frey has lived in South Florida for 30 years. He's been at the same address for 10 years. He works in the yachting industry. He has been for the past 3 years. He's been working as an engineer.
Got it.
His strong family ties, mom, dad, cousin. live here, no money in the bank and no property. We're looking for pretrial release on this, Your Honor.
Okay. Let me just State, do you have any priors on him? That's it? Okay. So I'm going to let you bond out. Your bond's $2,000 total, based on your criminal record, the facts of the case. Thank you. George Osceola.
He has Rick Castillo as his attorney.
Is Rick supposed to come back here?
He was here this morning. I mean, he's aware of it.
Hold on.
I mean, I don't know if he's aware that he would be in the, I knew he was aware of the arrest. Rick Castillo.
I don't have Rick Castillo's number. Thought I did. Excuse me.
I wonder how much of your
Do you have
stuff
Castillo's
actually
number?
picked up.
Anyone?
One moment, Judge.
Mr. Osceola, have a seat. We'll be right back with you. How about Rodney Lubin?
He has a private.
Who's your attorney, sir?
Joseph P. Clark. Joe Clark.
Joe Clark?
Yes, sir.
Do you happen to know his number?
At the moment, no.
Okay, and is he in Broward County?
His office is located in Miami-Dade County.
And it's Joseph Clark, I assume, right?
Yes, Joseph P. Clark. K-L-O-C-K.
You said C-L-A-R-K, last name?
No, K-L-O-C-K.
Clock.
Yes, sir.
Oh. K-L-O-C-K. Joseph Clock. See if there's any clock in
Well, I have Rick Castillo's.
Give me Castillo first.
954
Go ahead.
522 3500.
Hey, is Rick Castillo in? Yeah, this is Judge Hurley. Yes. Okay. Okay, can you give him a message for me? Tell him that George Osceola is going to have a violation of probation hearing on November 3rd at 9 a.m.
November 3rd, 9 a.m. I'm sure he'll be there.
Thank you.
All right, thank you, sir.
Yes, sir.
Have a good day.
You
I
too.
also have Joseph Clark's number.
Okay, give me Clock's number. Hold it. Just
305.
Give me time. Okay, I informed your lawyer. Sorry, I left a message. Thank you. How about Kevin Smith?
Which person are you talking to?
I'm talking
Lubin?
to Rodney Lubin. I called your attorney and left a message.
Is he coming? Okay,
No,
so
no.
are we
5,000
done with
on
him?
one, no bond on two. Thank you.
Got it, thank you.
Kevin Smith.
That was it. President the Maine, Your Honor.
How you doing, Your Honor?
Doing fine. Okay. Okay. Multiple. So you've been charged with license suspended, third or subsequent offense. Let me look here. Yes, I do find the 2 priors on here, and I do find that there are multiple failures to pay, failures to appear. So I'm going to set your bond at $750, sir. Thank you.
Good luck.
May I see Richard Bentley, Dennis Parker, Xavier Brown, and Willie Shivers?
Your Honor, Mr. Bentley is very anxious to know if he has a court date on any of his felony cases.
Yes, November 6th, 8:30 a.m. Mr. Bentley, you have warrants, pretrial. You have warrants, 9 of them. They're all no bond. Thank you. How about?
Sure, sir. Sir.
Yes.
Do I go back to my judge for this?
Yes.
For these charges on the 6th?
Yes, November 6th.
All of them on the 6th?
Thank you. Yes.
Thank you, Your Honor.
Dennis Parker.
Told you he was anxious.
Mr. Parker, altering a plate, not a sign, count 1. Count 2, grand theft. That appears to be a violation of probation. Let me look here. Hold on. Traffic stop was conducted. Tag was altered with a piece of paper with the... Oh, boy, that's... Oh, this is a signed warrant from Judge Rosenthal. Okay, sir, $25 on 1, count 2, no bond. Thank you. How about Xavier Brown?
President the Maine.
Sir, hi, good afternoon. Possession of cannabis and meth, count 2, court finds probable cause. Do we have any priors on Mr. Brown? So I'm going to send you to pretrial release. You got to be there tomorrow morning between 8 and noon, right across the street from the courthouse, all right? They'll give you a map right there. Thank you.
Thank you, Your Honor.
I'm gonna go home, right?
Yeah, but you have to go here tomorrow morning.
Yeah.
Check in with them.
What about
Regular
Willie
pretrial,
Shivers?
call in once a week. Okay. President
Hi,
the Maine.
Mr. Shivers. Cocaine, marijuana, court finds probable cause. Do we have any priors on this gentleman? Mr. Shivers, are you currently employed?
Yes, sir.
What type of work is that, sir?
I work at Palm Beach Rental as a truck driver, sir.
Okay, how long have you been a truck driver up there?
Up there about 9 months.
Wow, okay. Where are you from originally?
Raised from Carolina, South Carolina.
Which part?
South.
Which part?
Oh, Orangeburg.
Oh, okay. Go ahead. Sir, do you still live on 19th Street in Boca Raton?
Yes, sir.
Okay. I'm going to release you on, unless we got something on him. Sir, I'm going to release you on your own recognizance today. You have to report to pretrial release tomorrow between 8 a.m. and noontime. It's right across the street from where you are right now, all right?
One moment, Your Honor.
Go ahead.
Thank you, Your Honor.
Yep.
That's where you go.
Terry Shepard, Eugene Alzitz, Chelner Vassar, and Lazaro Cummins.
Hey, Eugene, how do you say?
Terry Shepard.
Shepard, present.
Mr. Shepard, resisting arrest without violence, riding a bike with no light. Riding a pink bicycle. No lights. Began to flee, dropped his bike, fled on foot. All right, sir. $100 on count 1, 3, and 4. Those are both $5,750 on warrants. Thank you. Eugene Alzitz.
Oots, Your Honor.
Oots, sorry.
And I do have an address, sir. I just don't know it.
Sir, possession of cocaine and tampering with evidence. Court finds probable cause. Do we have any priors on this gentleman, Oots? Sir, do you have a local address?
Yes, sir, I do. I stay off of 16th on 3rd Avenue. I just moved in there October 1st, and I paid my rent to the end of next month. I just don't know.
What's the street address there?
The street is 3rd Avenue.
No, what is the street address?
I don't know that. I don't know the house, the phone.
All right,
I haven't been able to use the phone to call my roommate to get the address. They won't let me do that.
I got it. Thank you. Go ahead, State.
Yes, 2011, possession of cocaine with intent to sell or distribute, possession of cocaine, resisting with violence, attempted tampering with evidence, over 42 and a half months state prison. 09, strong arm robbery with a VOP, same sentence.
Sir, are you currently employed?
I've been going to day labor, sir. I don't have an official job.
All right, do you have money in the bank?
No, sir.
Your bond is going to be $1,000 on count 1, $1,000 on count 2, based on your 2 convictions for cocaine and your strong arm robbery. Thank you. How about Chalner Vassar?
Present at the main, Your Honor.
Hello, sir.
Hi, Mr. Vassar. Sir, it's alleged that you work at you're a mental health tech at Atlantic Shore Hospital in Fort Lauderdale, right
Yes,
on
sir.
the Federal Highway there. I know exactly where that is. It's right near Holy Cross Hospital up there. And,
Yes, sir.
I actually had a client or 2 in there over the years, but you allegedly worked there as a mental health tech, and they claim you lost your temper and got into a tussle with a couple of juveniles who were causing problems there. And it does even say that one of the juveniles had been taunting you, and you allegedly rushed him. So
They rushed.
well, I got a feeling they were taunting you. The question is did you overreact? So
Well, let's take into consideration what this facility is, and obviously they have issues.
You know,
He's the one that's supposed to, or if he can't handle it, then don't work there. No, Judge. No. I know we've had cases where I know the court has taken a position.
School teacher, and she told me there were quite a few times she wanted to.
No. Yeah, but this is even completely different because the whole purpose of this facility is to treat these children with mental health issues. He's going after them? No.
Are you coming
Going
for the
after them?
curtain
Is that?
call a
I'm not
second
reading
time?
that.
Okay, well, do we have to go through the whole thing again, even if buying it, or is that one time?
Can we just?
One time is good.
Is the court considering pretrial release for Mr.
Well, I don't
Vassar,
know
Your
what
Honor?
I'm not sure what I'm considering right now, so give me a moment, I'll see what I'm considering. Let me ask you,
He had his, well, I just want to put everything on the record.
Go ahead.
Apparently he had his hand on the child's throat, had to be pulled off by other staff members, while this child was 5 to 6 feet away from him, so he posed no threat, no matter how much he was taunting him. Let's see. Oh, I'll check.
How long does he live down here? Mr. Vassar, how long have you been down here in South Florida?
All my life, 38 years, sir.
Where'd you go to high school?
Stranahan High School.
Really? So you're a dragon?
Yes, sir.
All right, now, do you have family down here?
Yes, sir. I have my 2 sons. I work 2 jobs. I have my 2 sons. I have my mother, my sisters, nieces and nephews. I live with one of my sisters. I work at another facility dealing with mental health patients. You could call them. I have an excellent record with them. I think there's more to the story than me.
I understand. Go ahead, does he have
Okay.
I'm going to release you on your own recognizance, but I'm going to order you're not allowed to go back to the Atlantic shores. You can't go back there. All right?
Okay.
And the other thing is,
Go
ahead.
I'm sorry, my vehicle is still there. I just want to pick up my vehicle.
I'll let you go get your vehicle, but then don't go inside. Just drive it away, and that'll be the end of it, all right?
Yes, sir.
I don't want you to have any contact with 2 juveniles, HP and KD. No contact
Never.
with either person, all right?
No, sir.
Okay, thank you, sir.
Good luck.
How can we make excuses for adults putting their hands on children in this community?
Okay, now, I need a point of guardian on that case. Ma'am, we're here for Spanish. Which case was that? Oh, that's up at Conti, right?
Yes, sir. Conti. He's on the second loop.
Who's that first up there?
Señor, ¿cuál es su nombre, por favor?
Edwin Grijalva.
Enrique,
Edwin Grijalva.
one moment, please, Your Honor, we're gonna look it up. My God, Edwin Grijalva, Grijalva?
Ajá, sí.
Don't worry about it.
Okay. Got it right here. That is it's a DUI, property damage, I understand. No driver's license. Hold on one moment. I handled this when it came through. A breath reading of a .181, and I gave him a $7,500 bond. And it's, right. Sir, how come you've not bonded out of the jail yet?
Señor, ¿por qué razón todavía usted no ha salido bajo fianza? ¿Me
No.
escucha?
Sí.
¿Por qué no ha salido bajo fianza?
No tengo familia aquí.
I don't have any family here.
Sí, aquí en Miami no tengo familia.
I don't have any family here in Miami.
Where's your family?
¿Dónde se encuentra su familia?
Mi mamá vive en Chicago.
Ohio and Chicago.
Do you have anyone's telephone number?
¿Usted tiene el teléfono de alguna de sus familiares?
El de mi mamá lo tenía, pero creo cambió de número.
I had my mother's phone number, but I think she changed it.
Sir, is your mother in Chicago?
¿Su madre se encuentra en Chicago, señor?
Sí.
Yes.
Your mother is going to bond you out of jail, sir.
Señor, de aquí de la corte le pusieron una llamada a su madre y ella lo va a sacar usted bajo fianza.
Thank you.
Gracias.
Okay.
Good job, pretrial, for being on top of that.
Is that it?
Okay, you want to make an announcement, ma'am?
¿Alguien más necesita los servicios de este intérprete? Por favor, déjenos saber ahora.
No? Okay, I think that's it.
That's it.
Ma'am. May I see Lazaro Cummins, Donald Pendlebury, David Dowling, Ronell Tucker, and Eduardo DeLeon?
Mr. Cummins present at the main, Your Honor.
Sir, your bond has been posted, Mr. Cummins. Thank you.
Good job.
How about
Thank you. See you later.
Donald Pendlebury?
I think he bonded too.
Did he?
Let me just check, Your Honor. Pendlebury. He's at North Broward.
Morning.
Hi, Pendlebury. Criminal mischief. Allegedly you went into a 7-Eleven while you were under the influence of drugs and destroyed their cash register, which looks like it's worth about $4,500. Smashed it with the skateboard and ruined the.
Oh, you think?
Ruined the cash register. Does he have priors? Sir,
Yep.
How long have you lived down here in South Florida, Pendlebury?
My whole life.
Do you have any money in the bank?
No.
All right. Who's going to bond you out of jail today?
Nobody.
Okay, go ahead, Steve.
Out of priors not from here, huh?
Just go to prison stuff, that's fine.
Traffic and dealing in stolen property in 2006.
This is a felony or misdemeanor. What is this?
I know, but it's just letting you know what we went to prison on that,
Who-
having stolen property. 2002 out of Broward, grand theft auto, burglary, dwelling in 97, grand theft 97. Sentenced to 2-year state prison on those.
Is this a felony or a misdemeanor?
This is going to be a misdemeanor. I mean, a felony, I'm sorry. So
It's gonna be a felony.
I'm going to raise your bond today to $4,500 in line with what you allegedly destroyed, and then it's based on your lengthy criminal record, too. Thank you. How about David Dowling? David Dowling? We had to reset this. I don't know if he's up. There he is. Sir, possession of heroin, buprenorphine, drug paraphernalia, and obstructing, I think obstructing traffic. Court finds probable cause, sir. And there was a black Honda Element blocking the roadway, prevented traffic from flowing in Deerfield. The caller advised he saw narcotics and drug paraphernalia in the vehicle in plain view. And they said the male in the vehicle was having a seizure in regards to a possible overdose. Said it was David Dowling sitting in the driver's seat of the Honda. They observed a black small rock, suspected heroin, sitting on top of the console. He had a syringe, gray spoon, cotton stuck to the spoon, sitting in the driver's seat. Field tested positive for heroin. Got it. Okay. State, do you have any priors on?
I don't have any information on him, Your Honor.
Sir, how long have you lived in South Florida?
My whole life, sir.
And do you live on Harbor Springs Circle at this time?
Yes, sir.
Who do you live with?
My mom and dad, sir.
And do you have money in the bank?
It's not in my bank account, sir. I give all my money to my mom due to my drug addiction.
Okay. And who's going to bond you out today?
I mean, I didn't get to call my mom, so I couldn't. They put me in suicide watch because the overdose or whatever.
No, I'm very concerned about your own safety. So I'm based on that great concern, sir, and the facts of the case, the amount of drugs involved, the situation involved. I'm going to raise your bond on count 1 to $2,500, count 2 to $2,500, count 3 to $100. Your bond today is $5,100. And you do live in Boca Raton. You don't live in Broward County outside of the jurisdiction. I also noticed that. So what I'm going to do is you can bond out for $5,100. Thank you.
Thank you.
So. Runwell Tucker, I think he's on loan to the hospital, so we'll reset this for Friday p.m. How about Eduardo Leon?
Yes, sir.
Where is he?
How you doing, sir? I wanted to tell you that what happened last night was that I was born. I went out the house because my sister was.
No, hold on. You don't need to tell me what happened. Not now. You tell your attorney what happened. I'm gonna find
Yes, they didn't let me make a phone call down there, so I can't have nobody to help me if I need the help because I don't know what's gonna happen right now. I have not done anything wrong. I just was looking for.
All right, sir,
one
hold on,
cigarette.
sir. You'll get a chance to
And
make
I-
a call. You'll get a chance. Stop
and I
talking.
banged
Stop
And I
talking.
banged them.
Stop
Sir,
talking.
please stop talking.
You-
We're trying to
Help you.
right through this process. Just give us a minute. I may ask you a question or two. State, do you have any priors on this gentleman?
Yes, Your Honor. I mean, yeah. Lots. 2011, Bat Leo, corruption by threat, cocaine, little under 26 months, habitual offender. 08, under the name Edward Robles, Berg structure. 08, loitering and prowling. 03, burglary of a dwelling, just under 48 months state prison. 03, grand theft auto, same sentence. Trespass 02, trespass 02. Criminal mischief 02, resisting with violence 02. Theft 02.
Okay, that's good. Sir, are you working at this time?
I'm not working, sir. I'm looking for a job.
Do you have any money in the bank?
No, sir. My sister received a benefit of Social Security for me.
Right.
And she's my payee, and that's what I'm living on right now.
Okay, I'm going to set your bond at $5,000. I raised your bond based on your prior burglary convictions, a grand theft auto, theft, a criminal mischief, and a resisting arrest with violence. Good luck. Thank you.
But I done nothing,
Yes,
sir.
Good luck.
What
Thank
I have
you.
done.
Okay, now, got that. How about, okay, so what time is he's coming in at what time, 3:30?
3:30.
Aye. Oh, well.
I think we still have some.
What about Deborah Conyers? Still do that.
Mr. Miller wanted to research the alleged victim.
Yeah, Mr. Miller, where's Miller? Miller, Deborah Conyers. She may have bonded out. Did she bond?
I don't think so. I'll check.
No. Paul Ryan, do you have Miss Conyers up there? Oh, yeah, I think she's in transit. I'm going to reset this matter for tomorrow afternoon, Friday PM. All right. Friday PM. Here you go, Miss Conyers. Now, set those aside. Okay. Now we're done at Maine, and Paul Ryan, Conti. Okay, I'll just go down the docket real quick. Okay, we took care of that. What about Rashad Strong? Do you have anyone strong? Rashad Strong?
He's still out to court.
He's out to court, so scratch that. Okay, scratch that. We're done with misdemeanors. Let's go to felonies. Barry Lee.
Rashad, they said Rashad.
Barry Lee.
Do they have Raymond Mitchell at Conti?
Yeah.
All right,
He's
thank
here
you.
too.
All right, I was just checking. Thank you.
Where's Barry Lee?
Right here. Conti facility.
Got it. Okay, Mr. Lee, give me a quick moment. 30-day stay.
I believe so.
Okay, give me a moment. Got it. Okay, Barry Lee, go ahead, sir.
One moment, Judge.
He's in jail 55 days. He must have other things.
Well, one moment, Judge. I'm checking.
Got it. Mr. Lee, do you have other cases holding you right now?
No, sir.
If you had any other cases while you've been in jail on this charge?
No, sir. I have that violation of pretrial release, which is a technical violation. I just couldn't comply with it, Your Honor. I had no way to comply with it.
Yeah, this is
a violation of probation.
Let me check. Well, I'm gonna check Odyssey here. That's what it's booked under. I'm gonna.
Yeah. It's pretrial release.
No, he's got a.
So should it go back to his?
Yeah, no, he's got a pending. No, it's not a pending VOP. Because according to this Odyssey, he never pled the case out. It's a pretrial release, but just want to see when he was running.
I haven't even been arrested since.
Oh, stop, sir. Your Honor, he's entitled to release.
So I'm going to release you on your own recognizance today. Thank you.
Thank you, sir.
On 149910 CF10, ROR is hereby granted.
Just decline the charges already.
think that's it, complete.
Okay, now,
That's it, please.
Master Control receiving gate for walker.
okay, so that took care of Barry Lee. That took care of that.
Okay.
How about Amanda Tyler? Okay, what is this, 30 day?
All right.
Yes.
I do not see a,
She's entitled to release.
okay, Ms. Tyler, I'm gonna release you from custody today, ma'am.
Thank you, Your Honor.
14-13066 CF10, you're gonna be released ROR, ma'am. Good luck, thank you.
Thank you, sir.
There you go. Okay, maybe, how about Joshua Shaw?
Yes, sir.
Where's Joshua Shaw?
He,
North Broward, sir.
Hi, Mr. Shaw.
Second look, he completed drug court last year for obtaining controlled substance by fraud.
Okay. Sir, your bond's $10,000 GPS. I wonder what that was about. Let me look here.
I don't know, sir.
Well, how come
I
you haven't,
so-
how come you haven't
I
bought
have
it
no,
out
I have
yet?
no, I have no, I have no money, and I have not been able to contact my family, sir.
Well, where does your family live?
My mother lives in Palm Beach, but I have not been able to call her. I haven't got a free phone
Let me
call.
ask you this. Where's your father?
I never knew my father. He
Okay.
abandoned me when I was
It's
born.
Eric.
Do you have any other family besides your mother in South
Just wanted
Florida?
to see if Cindy
My grandmother, she's 84. I don't want to bother her. She's 84 years old.
How often do you talk to your grandmother?
All right, thanks.
Not that often.
How often do you talk to your mom?
Every day. But I haven't been able to call her.
Right, so you've been gone for 9 days and your mom hasn't heard from you. I'll bet you your mother knows exactly where you are. I mean, if my child was missing for 9 days, I'd call the police, I'd call the morgue, I'd call the hospitals, I'd probably call the jail. So I have a feeling your mother knows where you are. So the issue is not necessarily about you calling your mother. I have a feeling your mother probably doesn't want to bond you out of the jail. That's just my gut feeling from doing this every day for the last 6 years, but let me look here.
Well, I don't think it's the money. It's the money, sir. She doesn't have the money. She's supposed to be buying a new place.
I got it.
She doesn't have the cash.
Hold on, it makes sense now. It all fell into place. I didn't read this. The defendant was identified by the victim, Renee Hersher, who is his 83-year-old grandmother. I think I know why your mom's not bonding you out of jail, sir. Yeah, I think I know why.
Yep.
I think your family's probably very upset with you. That's what it is. 18 karat gold earrings. 14 karat gold earrings. Cufflinks. Took the items.
Just didn't know that you knew.
Got it. He was identified by a jewelry shop as a person who sold his grandmother's jewelry. The defendant moved out of the residence in January after he was kicked out of his mother's home in Lake Worth, after he was caught stealing from his mother there. All right, sir.
Okay.
I'm going to let your bond stay where it is. Thank you.
Okay. I asked for a pre-trial. I didn't know if they were going to talk to me at all.
No, nothing's changed. Your bond's still $10,000.
Thank you. I don't mean to be a pain, but she has to be proactive because
Thank you.
It's not fair to her, but they're going to
So
push it
I
that,
did
oh,
that.
well,
stand down for about 10 minutes, and we'll wait for the attorney to show up. We're going to call, when I come back, we're going to call Avante Tenney and Raymond Mitchell when I come back in about 10 minutes. Thank you. May I see Avante Tenney, please? Avante Tenney. Hi, Mr. Jellin. This is Judge Hurley. We're on the record right now. Your client, Avante Tenney, is present at the Paul Ryan facility. Ma'am, can you hear me over there?
Yes, sir.
Okay, ma'am. I have your attorney, Mr. Jellin, on the telephone line, conference call. He's caught up in another legal matter right now. However, this is done quite often. Go ahead. Sure. Your attorney was already here this morning on your behalf. He was able to review the documents, speak with the prosecutor, so he was already here. We had to reset this case for this afternoon to an inconvenient time for him. So this is not his fault. This is the court's fault that your attorney is not here. It was unforeseen. I hope you understand, ma'am. But he can defend you right now over the telephone because he was already here. He's reviewed the paperwork. Am I pretty much correct on that, Mr. Jellin?
Yes, Judge. And again, I spoke to, I hope Ms. Tenney can hear me, but I spoke to her mom. Essentially, the situation is one in which, I'll just throw it back to you right now, Judge, just to explain, and then I'll pipe up.
Okay. Here's where we are. Ms. Tenney and her co-defendant, Mr. Raymond Mitchell, have been charged with tampering with evidence in a first-degree felony, which is punishable by up to life in prison. Count 2, she's been charged with criminal attempt to solicit or conspire in a third-degree felony. Now, State, is it your position that count one is a first-degree felony punishable by life, where if you seek to foreclose bond and release conditions, the defendant would not be entitled to release if there's a finding of proof evident presumption great?
Yes, Judge. We're just doing
Excuse me.
We're
Now,
not doing yours.
Mr. Jellin,
We're not doing the other one.
the issue before the court today is, pursuant to the Preston case and the Keel case, is that the state is seeking to foreclose bond conditions today, where your relief would have to be an Arthur hearing before your trial judge. Now, hey there. Now, if the court makes a finding of proof evident presumption great, bond is foreclosed, and like I say, that's your relief, is to have an Arthur hearing. Now, let me ask the state.
Yes, Your Honor.
State, will you please proffer for the court why you believe that there is proof evident presumption great regarding Ms. Tenney and these charges?
Your Honor, I believe based on the arrest warrant affidavit prepared by Detective
That I have screenshots
of the Hallandale Police
that the
Department,
victim contacted
that shows
me.
that proof is evident, or
Ma'am, just
Proof.
listen.
that proof is evident, or presumption is great that Ms.
I can't really hear you if you can speak up a little.
That Ms.
why don't you
Tenney-
why don't you come to my microphone? All right. Well, he's going to come over here.
Your Honor, relying upon the arrest warrant affidavit, first, that numerous phone calls that were made from the jail from Mr. Mitchell, Ms. Tenney's boyfriend, who's currently charged with robbery with a firearm, to Ms. Tenney, in which they go over with when his court dates are, and having her appear, quote unquote, with him, in which Mr. Mitchell advises her that she needs to call and let him know on Tuesday, say wrong person, tell him wrong person, that's the only way out. At which point she tells him to be quiet. Additionally, we took sworn statements were taken from the alleged victim, who identified Ms. Tenney, that she has approached him in the past. He's received multiple calls from Tenney and an unknown male claiming to be Mitchell's brother, advising him to advise the court that he picked the wrong person. And he stated, if you don't drop the charges and say it's not him, it's going to be whatever. The victim took this as a threat. The victim further advised that Ms. Tenney has previously responded to his mother's residence. Additionally, Your Honor, that the State Attorney's Office received a letter from Mr. Mitchell's attorney that was purportedly written by the alleged victim, stating that the victim identified the wrong person in the robbery case. Upon further investigation, according to the victim, one, the handwriting in his signature and the letter was not his, that he would not write a letter like this. Also, the last name on the victim's last name on the envelope is misspelled. Additionally, Your Honor, the alleged victim advised that he believes Ms. Tenney authored the letter because he was contacted by her about writing a letter stating that he made an error in identifying the defendant as the person who robbed him. Right. At which point he advised he would not write such a letter. Your Honor, I just believe, based on the totality of the circumstances, based on the allegations, that there is proof evident or presumption great that Ms. Tenney did interfere in the prosecution and tamper with the victim in the prosecution of a robbery firearm.
Okay, Mr. Gellin, do you have a response to that?
Correct me if I'm wrong, but proof evident presumption grade is a higher standard than beyond a reasonable doubt.
It's the highest standard in law that I know about.
Correct.
Right.
And essentially, that's why there's supposed to be witnesses there. There's nothing here but a bunch of hearsay that, or whatever you want to term it as, that essentially somebody, it tells me that he's somebody from a different jail. It's not even what's his name again? I'm sorry.
His name is Mitchell. Mitchell.
It's not even Mr. Mitchell. It's not even his PIN number from the jail. They're not playing the tapes for you. They haven't made any identifications with the boys. They haven't had any identification from the alleged witnesses that was her that came over there. They're talking about a letter that was sent over that they haven't matched up the handwriting samples or presented any evidence to get beyond that standard. Clearly,
Well,
proof evidence presumption grade has not been shown, and that's why they've got to have witnesses there, or play the tapes, or make the connections to draw the dots to the court that you can make no other findings but that, and they have there's no way that this is proof evidence presumption.
Well, for one, let me just say the Preston case says that the court does not necessarily need to rely on live testimony in court at the first appearance hearing for proof evident presumption grade. The court can rely on affidavits. And I do have an affidavit in front of me. Let me see, just make sure it's signed appropriately and dated. It looks like it is. Now, I have a paragraph here that the state did not read, or at least if they read it, I didn't hear it. The victim advised when he responded to court on June 23rd, he was surrounded by Miss Tenney, the defendant, and Mr. Mitchell's brother and sister. When surrounded, the trio kept telling him that he better let the court know that he picked the wrong person and to drop the charges. In fear of retaliation, that same day, he advised the state attorney that he wanted to drop the charges against Mr. Mitchell. The victim further advised that Tenney had previously responded to his mother's residence looking for him. Mr. Jellin, I do think that the proof evident presumption grade standard has been met today. Based on that, I'm going to order that the defendant be held without bond, and you can address this at a Arthur hearing before his trial judge, before her trial judge.
That was the last question for the court. Assuming you have now ruled that you found proof evident presumption grade, are you in a position, Judge, to at least release her or put her on pretrial? Considering, again, the level of the alleged threats don't seem to be on whether you're going to be hurt or killed. There doesn't seem to be any implication of violence. It's simply kind of an attempt to get this guy to change his mind or tell the truth about who the real perpetrator is.
Well, let me just say this. I've read the Preston case backwards, forwards, sideways, and then if you put the Keel case right behind it, out of the 4th DCA, that's Keel, I'm not sure of the site.
Your Honor, I can give
Hold
the
it,
site.
we're going to get you the site right now.
Joseph Keel v. State of Florida and Scott Israel. The 4th DCA's case number is 4D14-3104.
Based on the Keel case, the court believes that the court does not have the ability to exercise discretion at first appearance when the state has sought to foreclose bond and release conditions and there's a showing of proof evident presumption grade. It's the court's understanding that the defendant must seek relief through a full bond hearing at an Arthur hearing before his trial judge. And I've been consistent about that. And actually Keel went up for that, one of those reasons. So I'm, I don't think today I can give you the relief you seek, Mr. Jellin, but I appreciate you doing a good job on behalf of your client today.
Well, thank you. Can I just ask, can you hear me okay, Ms.
Yeah.
Tenney?
Ms. Tenney, hold on. Can you hear your attorney? Go ahead, Mr. Jellin.
Listen, I spoke to your mom already. I explained the situation. The fact is after Judge Hurley has ruled, we can only get a bond from Judge Hames, who's the judge on Mr. Mitchell's case, which you are connected to. I advise you just to stay off the phones. That's how they're claiming you got in trouble in this thing in the first place. Don't talk about anything over the phones, and we'll get you before Judge Hames and hopefully get a bond for you quickly, okay?
Your Honor, Your Honor, and
Okay,
Mr.
do you
Jellin?
have an idea when I'll be in court?
Ma'am, it may take a week or two to get that bond hearing set up. A lot of it depends on the judge's schedule. All right, ma'am?
Your Honor, just so Mr. Jellin's aware, Judge Hames signed the warrant. The underlying robbery firearm is with Judge Singal. I believe that's where these cases
This
are
is
going to be
probably
going.
going to go to Judge Singal, not Judge Hames. All right?
Okay. And last.
I think that's it. Thank you very much.
No, Your Honor.
What?
She is entitled to a bond on count 2. Oh. And lastly, we would also be asking for an order of no victim contact with Christopher Coverly.
I'm going to set count 2 at 10,000. All right, Mr. That's a conspiracy charge. All right, Mr.
Could you just do 5,000, Judge?
I'll do 5 because I don't know why. But
count 1 is what Judge Singal is going to be dealing with. So can we just do that?
Yeah, I'm going to order no contact directly or indirectly with the alleged victim, who is We know who the alleged victim is.
Christopher Coverly, Judge.
Christopher what?
Coverly with
Coverly. No contact
no
with
Z.
Christopher Coverly, directly or indirectly. Thank you. Thank you, Mr. Jellin.
Thank you, Judge. Bye-bye.
Bye. Okay, now may I see Raymond Mitchell? Raymond Mitchell?
Yes, sir.
Mr. Mitchell, you allegedly used Miss Tenney from the jail and perhaps your family members, your brother and other people in your family, to allegedly tamper with a witness in a first-degree felony punishable up to life. It's all contained within the affidavit here. There are telephone calls. They're taped. Go ahead, Steve.
Well, and one other thing, Your Honor, and I didn't
Can I
include...
Don't say a thing. Don't say a thing.
Didn't include this in Ms. Tenney's argument because, frankly, I think it's more relevant for Mr. Mitchell than Ms. Tenney. But Detective Banksill listened to the tapes. There were tapes of calls made from Mr. Mitchell's PIN number and calls to Ms. Tenney from other PIN numbers. And he said the voices are the same. So he compared that, was able to determine it's the same voice being made from other PINs and from Mr. Mitchell's. Also, I think the evidence that he's specifically speaking about his court dates. There's no co-defendant on his case. It only involves him, and it happens to involve calls to his girlfriend. I would argue proof evident and presumption great for Mr. Mitchell, Your Honor.
Okay. Now, Mr. Mitchell, you are seeking to foreclose bond and release conditions. Do you have a comment about proof evident presumption great today?
Yes, sir. My argument is going to be much the same as Mr. Jellin's. The evidence or the recitation of facts in the probable cause affidavit is hearsay. We don't have the witnesses here to testify. We don't have a copy of the tapes. There's nobody that identified. I didn't see that identified Mr. Mitchell. I don't think there's evidence, proof evident or presumption great for those reasons. Also, if the court were so to find, I would ask the court to exercise its discretion and set a bond. There was no violence particularly involved in this. As Mr. Jellin indicated, I'll hurt you, I'll kill you, I'll injure you, I'll shoot you. For those reasons, I would ask the court not to find proof evident, presumption great, and if you do, to set a bond.
I'm going to appreciate and compliment you on your argument, but the court will disagree with the defense today. The court will order that we'll find that proof evident presumption great has been shown today in the affidavit attached here too. The affidavit attached to his co-defendant, Ms. Tenney. The court also is going to rely on the Preston case and rely on the Keel case, K-E-E-L, out of the 4th District Court of Appeal. Based on those two cases, the court does not have the authority to use discretion when the court has found proof evident presumption great at first appearance, where the state has requested bond and release conditions be foreclosed. Therefore, the only relief the defendant can seek is through a full-blown Arthur hearing before his trial judge in an Arthur hearing. So I'm going to set his bond, proof evident presumption great. Now, State, did he have bonds on count 1 and 2?
At least one of the counts of robbery, firearm. I know there's no bond on that, right?
There's no bond on the trafficking.
Your Honor.
He has a trafficking.
Don't say anything, sir.
He had a trafficking case that was revoked, so he's being held on that. He's being held on the robbery, firearm, and now 3. He's entitled to a bond on 4.
Count 4, I'll set your bond at $5,000 like I did your co-defendant, all right? Thank you very much, sir.
And Your Honor, we would ask, even though it's already part of the robbery, firearm, just attached to this case, we would ask for no victim contact with, what's his last name? Christopher Coverly, Your Honor.
You indicated count 1 was the robbery with a
Your
firearm?
Honor, can I say something?
Please.
Some count. Okay, no, you're not going to say a word. First of all, and you're not going to talk to anyone on the phone. It's all recorded. You should have known that when you were over there, and that's noticed everywhere in the jail. No talking on the phone to anyone, only to your lawyer.
Okay, thank you very much, sir. You're going to be held without bond. Oh, and no contact. Say the victim's name again.
Christopher Coverly.
Christopher Coverly, no contact directly or indirectly. And, sir, I'm going to order that you limit your contact on the telephone to your attorney only. And I'm also going to order, and you're not allowed to go through anyone else's telephone usage. You can only use your own telephone privileges in the jail on the telephone assigned to you. And you're only allowed to speak with your attorney or someone in your attorney's office. And that's it. Thank you.
Your Honor, I have one question.
Go ahead. What's the question?
I have two little sons. I can't speak to my mom or my wife to speak to them or nothing.
They can come visit you. They can come visit you in the jail, but
And
I don't want...
I have another question.
What's that?
That my wife have evidence that she screenshotted him calling her phone.
Okay.
It was the other way
Stop.
around.
Hold on. You need to tell the public defender, the attorney representing you, what you just told me. Sit down and talk to them and tell them that, all right?
All right.
Thank you. Now, is there anything else before the court?
Judge,
Go ahead.
And if it's okay with the court, would it be all right with the court if I prepare that order? I have to get out of here.
I know. I need to go too.
Morning, if I could prepare that order tomorrow morning that you just ordered.
Got it.
I think we'll be
Got
fine
it.
overnight.
Okay, we're out of here. Thank you very much. Tomorrow is a very special day. It's Bow Tie Friday. We expect everyone, including our new prosecutor here, to wear a bow tie on Friday. It signifies the end of the week, and it signifies that we've done a job well done. So tomorrow morning, 8:30 a.m., I'll see everyone here, and wear a bow tie. Thank you.